Thank you, Andre. Appreciate it. And I'd like to again welcome all of you and thank you all for attending. Now, the topic of legal and ethical governance of AI takes us into some very uncharted territory. We start with the question facing the world today. And I mean, it is a global, not domestic question. What happens when technological innovation outpaces the ability of laws and regulations to keep up? And parenthetically, this isn't the first time we've had to ask this question. A lot of technical developments have brought us to this point in the past, but this is profoundly true with the development of artificial intelligence. Now, this phenomena of the law trailing behind technical development is called the pacing problem, and it has immense domestic and global ramifications for the governance of emerging technologies. While what to do about AI has become part of a greater legal debate, the pacing problem becomes the great equalizer in all of these debates and arguments because it forces governments to stop and to immediately take stock of what their approach to the regulation of these sectors and technologies will be. Now, today, in the next 20 minutes or so, I'm going to discuss some of the legal challenges and potential for legal liability created by AI and what some of the global players have done, like the EU. What have they done to address these legal challenges? And where is the United States relative to these global players? Well, I won't keep you in suspense. The US is far behind. Now, from a civil law perspective, when one individual harms another, either intentionally or negligently, the injured person, our plaintiff, has recourse in the courts and can sue the defendant perpetrator of the harm. And you can sue for damages arising out of some action in what we call tort liability. Now, we're going to talk about the inherent risks in AI technology in a moment, but I want you to assume with me for just a second that we all have some AI and it malfunctions and it causes harm to the public. And here's the question: does the law give members of the public redress in the courts to legal damages for the harm done? Now, in the current legal system, one human being is accountable for damage to another human being. So what we're really asking here is, how should the law proscribe human accountability for the disruptive failure of AI machine technology? Well, here's where the law is at on this. AI is a non-sentient being. It's simply an unregulated algorithm with disruptive potential, and as such, completely falls outside of the current US regulatory framework. Because domestic and international law do not currently recognize AI as a subject, someone who is subject to the law, AI has no legal personality and cannot be held personally liable for damages. In fact, the US courts have held on previous occasions that a robot can't be sued, right? Only a person with a mind can be an agent in the law. The question then arises as to how to hold accountable the multiple corporate and non-corporate participants in the supply chain who create, market, and apply AI and create or contribute to the risk of harm in the first instance. Now, in the corporate setting, we've all sort of heard of the doctrine of corporate limited liability. It's the reason most business organizations become corporations. And there is a separate legal personality that protects entrepreneurial activity without the constant risk of legal liability and financial ruin. And we know that these legal doctrines positively foster free enterprise in a capitalistic society, but they can also serve to facilitate the evasion of responsibility and accountability. Accountability is resolved, particularly, say, in the healthcare context. Quote, the lack of accountability raises concerns about the possible safety consequences of using unverified or unvalidated AI in clinical settings, unquote. So a key takeaway here is that a known risk in tort law sets the stage for tort liability. But for whom, right? So given that safety and security are cataloged as known AI risks, regulation to address safety could be difficult to adequately craft if there's no regulatory deterrence in place to ensure human accountability for the safety hazards accounted for and occasioned by AI. So how do we find somebody who's going to be liable? Well, in the past, when we had an inherently dangerous product or service, you can go back to the slide. If we had an inherently dangerous product or service in a supply chain, we would go back and hold all of the participants in the supply chain responsible. Now, holding every person or every business organization in the supply chain responsible is pursuant to rules called attribution, where the law attributes liability for a faulty product or service to everyone in the supply chain. Now, if we think about the AI supply chain, it might include the person paying for its design, right? The one who commissions it, the designer of the system, the person who writes the AI design, the software programmer, the person or business organization who licenses or distributes the system, the organization who integrates, installs, or configures the system, the one who tests the system, the person who trains the system or supplies the data to train that system. It could include the owner of the AI system or the hardware, or the operator of the AI system. So these are all the participants in the supply chain who could have future legal exposure. And yet, at this point in time, the law has still not applied supply chain liability to AI. Next slide. So I do want to talk about what the known risk is all about. Let's consider the safety risk in the context of an example. Let's take healthcare delivery. Now, we know that new technologies tend to be propelled into the marketplace by the exceedingly optimistic expectations of researchers and product developers regarding potential benefits. And there's a growing exuberance in applying large language models like ChatGPT in the healthcare industry to facilitate, for example, diagnostic activity. But is it safe? Well, the accuracy of ChatGPT algorithmic performance is still under research, and frankly, it's seldom addressed in the AI literature, touting its capability, and much of that literature is still subject to debate. But in a recent study conducted by Stanford University, the researchers found that the performance and behavior of both ChatGPT 3.5 and 4, quote, varied greatly over time. And they identified performance fluctuations as drift. Now, drift means that the behavior of the same LLM service can change all on its own substantially in a relatively short period of time, highlighting the need for continuous monitoring of LLMs. So drift is a term used in machine learning to describe how the performance of a machine learning model in production slowly gets worse over time. And this, of course, can happen for a number of reasons. The most common is that the data that the model was trained on becomes outdated or is no longer representing the current conditions. Now, while there are currently only a few published studies addressing the predictive accuracy of ChatGPT performance in terms of simply making mistakes or engaging in drift, there is a growing body of literature that points to other weaknesses in the application of this algorithm as well. And these include things like outdated knowledge, insufficient understanding, malicious usage, bias and discrimination, lack of transparency, security, and privacy. And in fact, the National Institute of Health, the NIH, published a recent study that tested the accuracy of ChatGPT performance in medical knowledge dissemination. And here's what that study concluded. There was potential for the use of AI in healthcare, but it cautioned that any use of the current version of ChatGPT for medical knowledge dissemination must consider its capacity to come to a totally mistaken conclusion, which is delivered in an authoritative and very convincing manner. So, would the law hold the AI supply chain liable for the risk of, say, diagnosis caused by a drift? Or would the doctor be held legally responsible for, say, medical malpractice based on AI reliance? Next slide, please. Now, as I said a moment ago, machine learning models are trained with historical data. But once they're used in the real world, as we said, they can become outdated, lose their accuracy, and be subject to drift. And therefore, they become less accurate, or they perform differently than they were originally designed to do. And if you take a look at the slide, you can see different variations of drift that can affect the performance and accuracy of AI. Again, as the model's predictions become less reliable, it can lead to consequences in the law. For example, in a healthcare setting, as we said a moment ago, it can lead to an incorrect diagnosis or treatment recommendations. Think about a financial setting. It could result in poor investment decisions, which takes us back to the legal principle that known risk can give rise in the law to legal liability. And next slide. And the known risks attributable to AI are legion. Now, I've talked about safety and security, but there are many other documented in the literature. And as one example, and I cite the article on the slide, researchers in this article did a literature review of 84 articles, and they identified 22 risks already raised by the use of AI. Again, if the risk is known and the technology is used, is there going to be legal liability as there would otherwise be for other known risks under current US law? Next slide, please. Now, there is another legal problem that has brewed up a recent storm. AI has been called a thief of protected copyright materials. Now, the US Copyright Office is right now trying to determine the applicability of the Copyright Act of 1790, which is the current law governing copyrights in the United States, to this new technology. And while it's going on and pondering the legal application, well, businesses are already starting to sue. The New York Times sued OpenAI, the creator, and Microsoft, alleging that these companies are stealing its copyrighted content to train their large language models and then profiting from it. Now, this is the only first such challenge by a major American news organization over the use of artificial intelligence, but other lawsuits have since been filed. Now, you might say, well, look, one defense to theft of intellectual property is known as the fair use doctrine. Now, fair use is a doctrine in the US that permits the limited use of copyrighted material without first having to acquire permission from the copyrighted holder. Fair use historically was intended to balance the interests of copyright holders with the public interest in the wider distribution and use of created works by allowing as a defense to copyright infringement claims. But the problem here is that no one knows what is fair use when AI is involved. In short, this has been characterized as a multi-billion-dollar business problem that is expected to control the ultimate contours of the use of AI in business. Remember, business operates in a regulatory environment, and we are going to see that these contours are going to be very costly, I would predict. Next slide, please. So I want to talk about the unresolved problem of AI ethical governance and compliance risk management. You might say, well, what's the big problem with creating an AI ethical code? Well, there is a consensus that the process of developing a cogent ethical perspective, a cogent ethical code that addresses the use of AI is a bit more complicated than simply just, writing a bunch of provisions into an ethical code. And the perception is that traditional ethical theories that focus on individual responsibility alone are inadequate now to address the ethics of collective decision-making that involves numerous and oftentimes wholly unrelated participants in the technology domain. The key takeaway here is that for the most part, while we do have some global regulation, ethical guardrails are currently missing. We really don't have a cogent ethical code globally or domestically. We're working on it, but it has not come to fruition as of this date. Next slide, please. So we've talked about current liability in U.S. courts and the legal system, and I want to now move to the global perspective. And again, I want to say that the complexity of defining an ethical code where collective decision-making of unrelated stakeholders is involved is as much a problem in the United States as it is at the global level. But let's consider what is being done at the global level. There are many, many summits and conferences going on, but perhaps one of the most important happened in November of 2023, which was titled the AI Safety Summit. It was hosted in the UK, and it resulted in a treaty being signed called the Bletchley Agreement. And Bletchley was signed by 28 nations, but what's interesting is it was also signed by participants from private industry. Usually treaties are signed by countries and not participants in private industry. So this is really very unique and a sort of a new aspect of these negotiations. You can see that the United States was part of the country who acted as a signatory, but also take a look. You've got Amazon Web Services, Anthropic, Google, Inflection AI, Meta, Microsoft, Mistral AI, OpenAI, and xAI. So you can see that now the private industry has become a critical stakeholder and player in global treaty negotiations. This is a whole new ballgame. And what the Bletchley Agreement recognizes is this, quote, there is a potential for serious, even catastrophic harm, either deliberate or unintentional, stemming from the most significant capabilities of these AI models. Given the rapid and uncertain rate of change of AI and in the context of the acceleration of investment in the technology, we affirm that deepening our understanding of these potential risks and of actions to address them is especially urgent. So the key takeaway from this global initiative is that these concerns are serious, they're urgent, and they require the participation of stakeholders based not based only in countries, but also in the private sector. Next slide, please. Now, let's just look at some of the features of the treaty. It is a call for international oversight, and it's through the use of risk-based assessment formularies. The Bletchley Agreement outlines a specific and focused risk-based regulatory approach with the end goal of providing legislative and regulatory protection to the public through the use of AI. The agreement sets forth these general risk-based principles. First, the need to identify AI safety risks of shared concern, and to do this in the context of a wider global approach to understand the impact of AI on our societies. And secondly, to build respective risk-based policies across countries to ensure safety given these risks, collaborating as appropriate, while recognizing that each country's approach is going to be different based on their national circumstances and their differing legal frameworks. Many of you may recognize this as the concept of treaty harmonization. It allows sovereign nations to come up with their own regulatory response. Next slide, please. Now, the European Union has moved very quickly to develop a 4-tier risk assessment platform and has formalized regulatory guidance in what they call the Artificial Intelligence Act of 2023. It is expected to go into force in 2024 in all EU countries. And, I'll simplify it. Here's how it works. The Act constructs a 4-tier risk model, prioritizing generic risk. Now, the risk level determines the measure of appropriate regulation. So as you can see, there's an acceptable risk for which there's no regulation that can account for it. It's simply outlawed. High risk, which has a range of mandatory legal requirements that will be applied. Limited risk, subject to a limited set of legal obligations. And minimal risk, where it's not expected that there will be any additional legal obligations at all. But sort of the bottom line here is that this will have an obvious impact on jurisdictions outside of the EU seeking to do AI business inside the EU. Next slide, please. Now, the United States has taken a completely different approach. Despite becoming a signatory on the Bletchley Treaty, the U.S. has no pending legislation at the current time. However, the Biden administration did in the past take steps to control the use of AI, but only in the government sector. Now, this is the Executive Order 13859, and it was issued in 2019. So it takes what we call a sectoral risk approach to risk assessment, meaning that we're not prioritizing risk. Instead, each sector or agency of the government is required to assess the risk in its own agency and sphere of regulation, and then decide which of those specific risks need to be addressed by regulation in its own sector. Next slide, please. Now, in 2019, the executive order covered these 4 particular risk categories and engaged all agencies of the federal government to conduct a risk assessment of just these categories on an agency-by-agency basis. So you can see it was not an overwhelmingly broad risk assessment approach. Next slide, please. In 2023, however, another executive order was issued by the Biden administration, and it broadened the risk categories for assessment. Next slide, please. Now, these categories are identified on the slide. The approach still remains sectoral. However, it has broadened. We're going to look at AI safety and security risk in terms of protection of privacy, protection from fraud and abuse. We're going to look at risks to consumers, patients, students, workers, all these stakeholders, all these externalities that are going to be affected by AI, and how AI affects innovation and competition. How it protects, how do we protect consumer and worker rights against the coming of AI, if you will? What are the transformative uses for AI in education and healthcare? We also want to ensure equality and civil rights because we want to prevent what has been proven as algorithmic discrimination. There is proof of it. And we want to ensure responsible government use risk and advance our own leadership abroad. But until Congress acts to review these questions, or the courts start to begin ruling on these pending cases, assuming they're not settled in the interim, the legal and ethical outcomes of this remain a mystery, but a potentially costly one for private industry. And as of this date, only a handful of government agencies have actually crafted any proposed regulations based on a sectoral analysis. Last slide, please. Now, I don't want it to sound like the private sector in the United States is not involved. We saw with the Bletchley Agreement that indeed the private sector is very much involved. The Brookings Institute is one private domestic organization, it's just an example, that has come up with a possible regulatory framework. Now, this regulatory framework includes a dual intervention process, and it's called the Critical Algorithmic Systems Classification System, known as CASC. So, first, federal agencies would be granted subpoena authority to investigate and audit algorithmic decision-making systems, ADSs, that affect processes related to a federal agency's authority. Second, CASC would empower federal agencies to issue and enforce regulations regarding these algorithmic decision-making systems. The CAC framework does not attempt to identify regulatory content, but instead it's simply offering a regulatory framework to allow federal agencies to pursue the task of regulating. It still remains a sectoral approach. And you'll note that nobody's really talking about how to limit AI in the private sector, because in a system of capitalism, that's a very touchy subject and one that the courts and Congress are going to have to deal with. The key takeaway: regulation is clearly favored domestically and globally, but it remains pretty much an unknown in the United States. Technology has outpaced our legal reality. Thank you.